Tonight, we're talking about the all-important process of jury selection in the trial of the men accused of murdering Ahmaud Arbery. And just 2 days in, both sides are already getting a warning from the judge to speed things up. Outside the courtroom, people from across the country have converged on the small town of Brunswick, Georgia, emphasizing the nationwide impact of this trial. BNC's Dre Clark is there with the latest.
Day two, and still no juror selected for this trial here. The judge presiding over the trial expressed some level of frustration today, telling both the prosecution and defense they need to do a better job of moving things along. There was supposed to be another group of 20 potential jurors questioned today, but the judge allowed them to go home, saying he just did not feel good about keeping them inside a room while they still question potential jurors from yesterday. The goal is to eventually seat 12 jurors and 4 alternates, but of course the challenge is finding a jury that can be fair and impartial. This case has generated massive media attention, so going into the trial there is great concern that they may not be able to, or at least it will be very difficult to find members of the jury who can be fair and impartial. Meanwhile, Greg and Travis McMichael, who are father and son, along with William Bryan, are on trial for shooting and killing 25-year-old Ahmaud Arbery in February of 2020. Arbery was jogging when the McMichaels chased him down in their pickup truck and then shot him at point-blank range with a shotgun. William Bryan was in a separate vehicle and recorded the shooting on his cell phone. Video of the shooting was not leaked until 3 months after it happened, and that's what led to the murder indictments. Now, the shooting happened in a suburb of Brunswick called Satilla Shores. Today, close to 100 black people who came here to Brunswick from all across the country to support the Arbery family went back to that neighborhood along with Ahmaud Arbery's father, and they held a prayer vigil. They actually walked the same route that Ahmaud Arbery was running when he was shot and killed.
This one just really hits you when you see what happened, when you look at the distance from the house that he was supposedly gone to and the distance to where he ended up killed, and the fact that it's really not that far, and you know that these people had to have known that Ahmaud comes this route and must have been either waiting on him because it happened too quick. So it makes you feel like, you know, people are hunting people, and it's just sad. It's so sad to see this. It breaks my heart.
We spoke with another woman also here today, Anita Brennan. She's lived here her entire life, and she's also friends with Ahmaud Arbery's family. She says his killing brought tremendous pain to the black community here, but at the same time, they remain very optimistic that justice will be done and that when this trial is over, it will end with 3 guilty convictions. In Brunswick, Georgia, I'm Dre Clark for Making the Case.
Today, attorneys were slowly working through a pool of 1,000 prospective jurors to get 16 people who can be fair and impartial in this high-profile case. But with the issue of race emerging as the central theme for a majority of the questions, both the defense and prosecution are finding it difficult to get to that lucky number 16. All right, my co-counsel, veteran prosecutor and BNC's legal contributor, Paul Henderson, is with me to discuss day 2 of voir dire. Paul, there were some interesting responses from these would-be jurors that could be indicative of the direction this trial could go in. They weren't shy about sharing their opinions. Let's start with juror number 72. The prosecution asked this prospective juror, a woman who appears to be white, if she can put aside all she's heard and decide the case based on the facts. Juror 72 said absolutely, but she also said what happened to Ahmaud Arbery wasn't justified and that she doesn't believe in vigilante justice. Here's my concern, Paul. I'm not sure if this questioning was done in the group setting with, 19 other prospective jurors, or was it done one-on-one? But let's just say it was done in a group setting. Who is going to be honest with 19 other strangers, right? Never met you a day in my life, but I'm supposed to be here sharing my thoughts, right? If the judge was asking these prospective jurors one-on-one. You're not going to tell the judge that you can't set aside whatever you feel and follow the law. This is a judge talking to you, right? So I have an issue with how honest these jurors can be. Your thoughts?
I agree with you, and this is why it's really important, which is why I'm always trying to have my lawyers and myself, when I'm in front of a jury, to try and be natural and comfortable, to try and elicit people to just speak to you regularly and try and forget that everyone is hanging on their every word and paying attention to everything that they're saying, and a court reporter is recording verbatim what they're saying as well, so that they are more honest and truthful. And then, like when you get the responses that we were just talking about, that you can try, at least from the prosecution's perspective, try and rehabilitate that person to make sure that at the end of the day, you are making a record that that person still believes that they can be fair and impartial to hear all of the evidence fairly, right? Because that's certainly what happened with a response like this. Someone is scrambling, trying to make sure, like, ooh, you're saying some good things for prosecution. We don't want to lose that juror. That's a big deal. And you know that that's the conversation that takes place on both sides. Everyone is taking notes on how you can follow up and wait your turn to get to that juror, either to submit them or rehabilitate them if they're good or bad for your case, depending on which side of the aisle you're sitting on for your case. I love that.
Well, let's look at how the defense handled this same juror, number 72. She told the defense, based on what she knows, if Arbery had been white, this probably wouldn't have happened. The defense asked her why she believed racism was the motivation. She said, quote, "I think if it was a white guy running through the neighborhood, I don't think he would have been targeted as a suspect." Paul, this is the type of honesty you rarely get with jurors, at least in my experience of picking a jury. This is precisely why the defense asked the judge to consider those additional 30 questions that pertain to racism, to the Black Lives Matter movement. This is what they want to get to. This is a person that I would strike as a defense lawyer.
Yeah, of course. And you see that they are being very honest. And here's the thing, Yodit, that what I'm paying attention to and what I'm noticing here is that people are being very honest. And one of the things that is in the back of my mind is part of the reason why I think we're getting such honesty from this group is this is a small town and a lot of people know each other. So a lot of people have strong opinions and they know a lot about this case already before they walked in the door. And if you think about it in context, that over 1,000 people have been subpoenaed for this case in a town that's just over 16,000, it's really likely that people know a lot about who is sitting in those seats next to them or in that pool. And we're still talking just about a group of 20 people. The bigger issue is they've got to speed this process up, even though they know a lot of these answers ahead of time from people about what they're going to say predictively about race and predictively about vigilantism. And so, it's a challenge for the lawyers, but they've got to move faster. This is day 2. If they keep it up at the pace that they're going, where they're doing 20 a day, it's going to take jury selection 50 days before we get anywhere. That's just not going to happen for this case. So.
All right. The defense now pushed further on race with juror 72, asking her whether she thought someone who had a bumper sticker or yard sign of the old Georgia state flag, which incorporates the Confederate flag, was racist. Juror 72 said that person might not understand how the flag made other people feel or may feel it's part of their heritage. When the defense pushed further and asked her whether she had Southern heritage, she said, quote, "Yes, but the Civil War is not necessarily my heritage." Okay, again, I don't know if this line of questioning was done in a group setting or individually, but the defense, I feel, had enough with her initial statements to strike her, but they probed more and they run the risk, Paul. When you ask questions and you keep poking, you run the risk of other prospective jurors being influenced by that one particular juror's response.
That's exactly it. And the strategy sometimes when you know that you may lose a juror, maybe to get them to elicit more information that other jurors are hearing that clarify exactly what they're talking about. Those answers that juror was giving was, I think, really helpful in trying to frame the issues around this case. What I think and what stands out to me from this line of questioning is that we don't have the runaround about race. Race is at the very center of the conversation here. And that's where the lawyers are focusing on, trying to get the attitudes, perspectives, and approaches to understanding nuances about race, because there's some complicated things to unpack in this trial. Vigilantism, the suspicions of the defendants that murdered Ahmaud Arbery, their false beliefs about who he was and his behavior. All of that goes right back down to race. And we are going to hear complicated conversations about race from this jury. And that's what we're trying to elicit and put out in the light of day. And that's always a complicated conversation that's exacerbated by having to overlay it with a legal analysis to get to a verdict.
All right, now, Paul, prospective jurors were also grilled on where and how they get their information. Juror 52 told the defense that she's been curious about the incident since the beginning because it happened in her community. She also said the majority of the comments posted online about the shooting had been negative. Also of note, she said, quote, some of the things I'd post, I didn't even read the entire article. This is so honest, again, because there are people that do that. They post things based on whatever headline they read. It's clickbait. It's what they think is the, you know, what the article is actually about. Let me post this, but don't actually read the substance of the article. So that isn't necessarily disqualifying, but it is concerning. And this is when attorneys need to go and start looking up the social media of all of these prospective jurors, because this was an issue that came up in the Derek Chauvin trial.
Yodit, that part, because you and I had the same reactions about hearing stuff like that, because I would be writing down yikes as they were answering, trying to figure out how am I going to scramble and get someone or tell my paralegal or assistant, can you look this up and Google it or figure out right quick what these postings are? Because there's so much that's going on in a trial like this where you're trying to stay on top of it and take these responses and make your gut decisions about people, good or bad, and then argue either to rehabilitate them or stop talking because they've said enough, you think they've indicated enough to let you know that they're supportive of you, and then they throw something out there like this, and you're like having to scramble in the moment to try and figure out a decision about this potential juror. I know you know what that feeling is like because we're having this conversation about that answer. And it can be nerve-wracking, especially in a case like this where the stakes are so high. But keep in mind, beyond, again, what's going on in the background. Now, there are more people in that room that know that prospective juror, that really know her or him better and have an opinion as to whether or not they would make a good juror. And you don't have the benefit of the doubt to know that. We really are stuck with the voir dire process and the questions that we can ask in the moment to try and make a determination about whether or not they're going to be appropriate. And that's happening on both sides, and they're not the same, and they're not always agreeing.
All right, Paul, hang tight, because after the break, we'll talk about that infamous video, which will be a key piece of evidence for the prosecution, and what prospective jurors had to say about it. We'll be right back. Tonight, we're breaking down day 2 of jury selection in the trial of the men accused of murdering Ahmaud Arbery, Travis McMichael, Gregory McMichael, and William Bryan. Still with me is Paul Henderson, BNC's legal contributor. All right, let's talk about the video, Paul, that shows Ahmaud being chased through this predominantly white neighborhood in coastal Georgia. Prosecutors asked several prospective jurors if they've seen it, including juror number 73. She said, quote, "If I have, it's been a long time." She said she doesn't typically watch the news, but the story was hard to avoid in the days after Arbery's death. Paul, I would be concerned as a prosecutor, because what do you mean if I have? You either watched the video and were moved by it because you can't not be, or you didn't. So for her to say, if I have, and it's been a long time, she wasn't moved by it if she did see it. And if she didn't, where have you been hiding?
Yeah, that's the same red flag that I would have with that same comment. But I'd be trying to balance that against, is it maybe just that she hasn't seen it in a long time and it didn't resonate with her because she doesn't care about it? Or has it just been that it did resonate? Because how can you see a video like that and not have it resonate? And so I would definitely have a red flag and have to follow up with her as to whether or not it impacted her when she saw it. But you run the risk of revealing too much and then having her say, like, no, when I saw it, I definitely thought that these people were guilty, right? You don't know what they're going to say because these aren't our witnesses. These are just the jurors. So it's always rolling the dice how you ask your questions and what questions you ask them, because sometimes they'll give you too much, and that truth eliminates them from the possibility of sitting on the jury. So it's always a judicious kind of dance from both sides when you're trying to elicit information like that, because the video, as you know, speaks for itself, and it shows us modern day lynching. These men went out, pursued, and killed Ahmaud Arbery unjustifiably while he was doing nothing that should have elicited that response. Those are just facts. So it's hard to get jurors to come in with those facts, with that video, to be indifferent or objective about their exposure to that video. It's really at the heart of everything in this case.
Paul, at least one juror specifically addressed the concept of a citizen's arrest. Juror number 89 told the prosecution, quote, "Taking the law into your own hands, I don't believe or feel that citizen's arrest is meant to be that way. You don't chase someone down." All right, so juror 89 essentially deflated the defense's case for citizen's arrest, but that doesn't mean that this person, this juror, could find the defendants guilty if they were following a law that was effective at the time of the killing.
That's correct. I mean, and like I said before, I think this, at the heart of this case, aside from the video, we're going to unpack some really complicated issues similar to the stuff that we've talked about in Trayvon Martin, but specifically articulating a conversation about vigilantism, which is law enforcement action without legal authority. And the whole case turns on whether or not, the question is, was it legal? And certainly the law has changed. And that's one of the things that's a fallout because of this case, is that citizen's arrest has been re-reviewed and withdrawn in that area because of this case, along with the approach that the entire state had with hate crimes. And that's a natural recourse to be addressing, and one of the legal issues that both lawyers are going to have to balance in terms of educating this audience about what may have happened as a result of this case versus what the state of the law was at the time of this case. But the bigger issue in this case specifically, because this is the criminal trial, is whether or not this was a murder. I believe that it was, and that's where they're going to have to focus. But they're going to have to dance around the nuances of those other legal issues, especially because the law changed, and these jurors, separate from what they know about this case in specific, may have a different understanding about how the law may or may not have changed, and that might confuse how they see what the defendants did in the case. That's the lawyer's job to be arguing that.
All right, Paul, in the last segment, you mentioned speeding this process up. Well, we talked about the judge warning both sides to pick up the pace. I know the court has a timeline to follow, and keeping people for long periods of time when they've got a life to get back to is important, but it never sits well with me when lawyers are rushed to get through the jury selection process. Regardless of how I feel about the defendants, they deserve to get a fair jury. It's important that Ahmaud's family gets a fair jury. So there's just too much at stake to rush this along.
Yeah, and you know that feeling when the judge is telling you, like, keep it going, one more question, and you're like, I've got two. Which issue do I decide to follow up on, and my answer or rebut that answer? And, you know, it's a really tricky thing. But like I said, we're only on day 2, and they are still on the first panel of 20, and there's 1,000 people that have been called in. They've got to speed it up a little bit more, and they should have some indication about these jurors that's going to be able to help them move this along a little bit faster. Nobody wants to make a mistake, right? Nobody wants to put someone on that jury that they should not have, that tanks the outcome that they want to try and argue for. And quite frankly, I'm a little more sympathetic with the judge in this case, because they do have a large volume to go through, and the jury selection process at this pace is taking longer than we expect for the trial to take. So yeah, they've got to move things on a little bit faster, and the judge can probably be leaning in to put pressure on those attorneys about, hey, speed this up. That's enough follow-up. And that's what I expect to see over the next few days. He's going to start, or the judge is going to start leaning in more and more and restricting how the lawyers are following up on the questions that they have with these jurors as they come in to be asked questions.
Paul, what do you make of no one wanting to sit on this jury? When the lead prosecutor asked if anyone in the room wanted to serve, raise their hand, no one raised their hands. I mean, I'd be concerned if anybody did raise their hands. You shouldn't want an overzealous juror, because you'd have to wonder why they actually wanted to serve. Do they have an agenda? But nobody raised their hands.
Yeah, because on top of not knowing a lot of people in a small town, you're also in an enclosed group, and nobody wants to self-identify in that small group of 20 people either. Like, I want to be a part of this. Now, I don't know if I would have raised my hand in that situation either, but it's certainly telling. And as you mentioned, would have raised a red flag to you and to me as well, because good or bad, I would be scrutinizing those answers more for that person when they came up and I could ask them questions. I think, listen, because the issue of race is such a personal one and such an important part of this conversation, and no one wants to be on the wrong side of that analysis in a public setting, especially in a small town, I think all of the answers that are being elicited are weighted, especially in the context of what's behind the decisions and the lens that people have about race, with the facts, circumstance, and evidence that's going to be presented in this case that I don't believe people don't know about by this time already. It's a lot to be weighed out and a difficult process to go through for voir dire.
All right, veteran prosecutor and legal contributor Paul Henderson. Paul, from one trial geek to another, thank you so much.